Right, okay, good morning everybody and welcome to the Matter 1B hearing session concerning habitats regulations assessment. Anybody who doesn't know me, my name is Malcolm Rivet. I'm one of the two inspectors appointed to examine the plan for soundness and legal compliance. If I can just remind you that the session is being live streamed to YouTube, and also just to say that if you choose to record the session yourself in any way, please ensure that you comply with the law if you choose then to distribute it or publish the recording. As I think you're all aware, it's a roundtable discussion which I will lead. If you want to be brought into the discussion at any point, please use the hands up facility. The main items I want to discuss today, and I'm hopeful that this won't last the whole day. I'm sure that'll be a relief to everybody. I say hopeful. Are air quality impacts from traffic and recreational disturbance from residential allocations. And although it's not directly an HRA issue, I think it has been referred to in the Statement of Common Ground with Natural England. So I just wanted to also touch on the two site allocations, which are on what I understand are on priority habitats. So I just wanted to touch on those. And then initially, just as we start, very briefly, just wanted to touch on Airfield and Pin Mill, just as far as any HRA implications go, but hopefully very briefly on those. So I'll ask everybody to briefly introduce themselves in a second, but before we do that, are there any questions or queries from anybody? No? Okay. In which case then, if I could ask everybody just to briefly introduce themselves, start with the council.
Thank you, sir. My name is Michael Bedford, Queen's Counsel. I'm a barrister instructed by the two councils to assist them on the legal support in relation to the joint local plan. We've got various team members here. Do you want them to introduce themselves on the basis they might need to speak? Or are you happy? Yeah. All right. Well,
we haven't got hundreds here today, have we? So it won't take hours.
No, right. All right. Well, Mr. Hobbs, obviously, so you're familiar with from the council directly. And then I think we've got three consultants from Place Services who, so you will have seen, are the consultants that were engaged by the councils to undertake the habitat regulations assessment. Claire Dawson, who I'm not, she's, but Claire Dawson, sorry, from the council, who did speak at the sessions earlier when we dealt with the strategic and environmental policies dealing with biodiversity. But obviously your colleague Alison Partington dealt with those sessions. And then Hamish Jackson and Sue Hooton from Place Services, who were responsible for undertaking the work in relation to the habitat regulations assessment.
Okay, thank you. And then I think it's Mr. Kench, isn't it? If you'd just like to briefly introduce yourself.
Yeah, that's correct. I'm Sam Kench from Natural England, and I'm a lead advisor in the Sustainable Development team for the Norfolk and Suffolk team, although I primarily cover Suffolk. So I've been representing Natural England on the local plan here.
Right. Okay, thanks very much. Well, as I say, if we can very briefly touch on Airfield, just because representations in relation to the HRA have been submitted in relation to that. But just if my understanding is that Airfield lies outside the zone of impact of any of the relevant habitat sites for HRA, so therefore it isn't considered to be a concern. That's my understanding is correct, is it?
That's only the council's understanding and the council's position, yes. So.
Right. Okay. So that's fine. In terms of Pin Mill, the designation for boat moorings, we discussed this back in the summer, and we'll be coming back to it again next week. But just in terms of HRA, I noticed that the HRA recommended project level HRA for any planning applications, and that's now in the policy. I just wondered why it was deemed appropriate to go for project level HRA as opposed to any sort of HRA of the designation as such. Is there a reason for that?
I think the approach that was taken is it would be sufficient to enable the compliance with the habitat regulations to leave that matter to the project level stage, and that I'm not sure that we thought anything terribly useful would come out of trying to deal with it in more broad brush terms, simply at the plan making stage. So I think that's probably the thinking. Obviously, so far as what is sometimes called down the line assessment is concerned, it can be legitimate, provided that this might sound the odd choice of word to use about houseboats, so long as it's watertight. That's to say, so long as you're sure that the project can't actually proceed unless there has been a project level assessment prior to any grant of a development consent, then the framework that's provided by the policies, and obviously the strategic policy SP09 together with LP18, noting that we've agreed already with Ms. Partington that we need to look at the wording of some of those elements, but those policies taken together would provide sufficient, as it were, assurance that nothing could come forward at the development management stage which wasn't appropriately subject to habitat regulations assessment. So that's the watertight element, and therefore I don't think we needed to go further than that in order to provide an adequate suite of protections in relation to Pin Mill.
Okay. Okay. Thanks for that. Okay. Let's move on then to air quality impacts from traffic. So just so I just going to say my understanding of it, and you can then confirm whether or not that's right, which is that this concerns air quality impacts from traffic on roads within 200 metres of the protected habitat site. So it isn't. So I understand this isn't directly related to any development in. Well, I suppose it might be if there is something within 200 metres or close by, but it's concerned with the general traffic on the roads nearby, not the direct implications of any development in the plan. I think that's the case. Yeah. There's baseline monitoring data currently underway, and that's likely to be completed within a year or so. And the view is that if that finds there are problems, then a review of the plan will be undertaken, and an update of the plan would then be submitted for examination with appropriate mitigation measures in. Is that everybody's nodding, which I like? So that's good. So just so in terms of this, isn't as I've already said, this isn't a case of here's a site allocation in the plan that might give rise to some major problem, and we're saying that we'll only find out once this monitoring's been undertaken. This is a case of existing traffic on these roads. Yes, that might rise over the plan period, but basically is there an existing problem, and if the traffic does increase over the plan period, that's likely to be background traffic growth, predominantly, rather than anything related to any individual allocation or proposal of the plan. Is that's right? Is it my understanding of all that?
Well, I think it's certainly that's right at a high level. Certainly, it's possible that individual developments will themselves be contributing to that, as it were, global, if I can call it that, effect. It wouldn't be right to say that it's only background traffic, in the sense that the developments themselves will be a component of increases in background traffic. But certainly we haven't identified that any individual allocation is likely itself to be, as it were, a cause of a problem. But nonetheless, as it were, to bear in mind the precautionary principle and so on and so forth. Again, if you go back to SP09 and LP18, in terms of the way that they are worded, and I preface it by saying that we've already agreed to look again at the wording of those policies, but SP09 is, as it were, at the strategic level, is setting out in the last sentence of part 2, as it were, a general requirement for a need to submit evidence of compliance with habitat regulations assessment regarding predicted impacts on relevant designated sites. So that gives the council the ability to require project level habitat regulations assessment when a site comes forward for consideration. And then LP18 in its part 2 item A is clear that where there are likely to have adverse impacts on designated sites, they will not be supported. Whilst obviously the monitoring of baseline conditions won't be producing an output until, I think we've said it's now expected this year, and it's a 12-month monitoring, but then it's obviously got to be analysed and assessed once you've got to the end of the monitoring period. So we won't have that until November 2022, but obviously from the point of adoption of the plan, we will have the suite of policies SP09 and LP18, which would provide the ability, in the event that an application came forward where it was thought, well, that might trigger a concern in relation to air quality on protected sites through roadside traffic impacts rather than site-specific impacts. Those policies would still provide the council with an adequate as it were, framework to require that matter to be assessed by whoever was proposing that in the interim period before we've got the results of this baseline monitoring. So, albeit that it's perhaps not the tidiest way to do things, there is still an adequate framework there to ensure that, in a sense, whichever way it turns out, there would be no adverse effect on integrity of the protected European sites.
Okay, that's helpful. Just on the wording, you've then got the modification proposed to SP09, introducing the clause 4, and I think my colleague indicated the other day that would be, she felt that was necessary. That I agree with. The only thing is, I think it should perhaps be reworded slightly, because it's committing to a review, but the review, this comes down to perhaps semantics of what a review is, but plans have to be reviewed and then updated if necessary, if you see what I mean. The update isn't the review. So I was wondering whether wording along the lines of, should the monitoring of air quality from traffic on roads within 200 metres of protected habitat sites demonstrate an adverse effect on their integrity, then the councils will submit for an examination an update of the plan to include the required avoidance mitigation measures. So to make that clear, because the review is really what you'll do as soon as you'll get the evidence, isn't it? You'll then, you know, as soon as you get the results, you'll decide, well, do we need to review the plan? No, we don't, or yes, we do. That's the review. It's the update of the plan that is the key thing.
Yes. No, I think we would accept that. Yes, you're right that the word review is sometimes used to mean different things to different people, and it's probably clearer to make it clear that it would actually be revised proposals of the plan to actually implement a revised mitigation or avoidance strategy. So yes, we can look at that and obviously make that clear. Okay,
and just. This is a side point, but just to mention it, because otherwise I might just forget I forget the document number, but the council's text suggestions to the inspectors. We don't need an update of that now, but when that's next updated and following the hearings, there's gradually lots of stuff is going to go into there. Could we have it in plan order? Because at the moment it's in, I think it's in the order that the issues were sort of raised or thought of or whatever. It's just as it gets bigger and bigger, it gets very difficult to find anything, as you have to sort of look through it trying to find what it is. So if that could be re-put into
plan, so certainly we can look at that. It's H.07 is the document. What we've done so far, and this obviously will have a bearing on that, is we have numbered the suggested text changes sequentially from the order in which they've been put forward, so that, for example, ST01, which is the first one, relates to policy LP09, whereas ST02 relates to policy SP02. And obviously, if we follow your suggestion of putting them into plan order, LP09 would be some considerable way after SP02. It's a question of avoiding confusion, particularly to third parties. Would you be content for us to retain the existing ST numbering system in its current sequence so that it doesn't change even in a revised document, or would you prefer us to renumber our own reference numbering so it then follows plan order as well?
I don't get. So are you saying that you would put it into plan order but keep your ST references there?
Well,
they would then all be out of
sequence. The reason for doing that is that there are a number of documents that we've already issued in terms of hearing statements, which cross-refer to those, and it would be confusing, I think, to people if we change that numbering system. But as I say, in presentation terms, if we put it in plan order, there will just be the current ones will then themselves be obviously slightly out of sequence, but we could do that. I say Mr. Hobbs is just
no, I mean, from my point of view, as long as if it's in plan order and it's then got different the ST numbers are all out of order, and that's fine. Sorry, Annette, did you want to? You've got a view on this, obviously, but.
Sorry, I was just going to suggest another option in that is having the start of the track change document as a way of readily being able to see all the changes together. The council obviously have to do that as part of their final process in any event, but that can be another helpful way of seeing the changes together.
Okay, perhaps. I mean, I don't think this is going to be updated much before the end of the hearings, anyway, is it? But perhaps towards the end of the hearings, we can have a discuss. You can have a think in the meantime as to the best way.
And if we liaise with the programme officer to make sure that what we're doing is as helpful to you as we can make it.
And it's not really relevant today. It was just that in looking for that ST094 wording this morning, I was like looking this thing. Where is the thing? Where is the thing? Yeah. Okay, Mr. Hobbs.
I was just going to say, rather than necessarily going down change at the moment, just really sort of saying that we got the referencing number, DST numbers, which we're obviously working with, and perhaps if we can keep it in sort of page order, even so, like say plan order, sort of so page 1, these are changes, page 2, etc. Then perhaps that's how we need to order it. But I think the references, the ST references, are quite important to us.
Yeah, it's fine for you to have those, but I think they're perhaps useful to you, but in terms, you might remember those off by heart. But in terms of anybody else coming to look, you think, well, what's the order of the plan? That's the order that the things will appear, but they don't. Okay, well, let's leave that one for the moment. Okay, is there anything else on air quality impacts from traffic? My understanding of the situation was correct. You're going to look at the precise wording of that, the modification, just to make it clear that that there will be in the event that there is an adverse effect, then there will be a update of the plan to deal with mitigation. Okay, nothing else. Okay, let's move on then to recreational disturbance from residential allocations. And again, if I can just set out my understanding of the situation. So this concerns, this relates to all new dwellings within the zone of influence of the Suffolk Coast RAMS, and that's, I think, a 13-kilometre zone of influence. That's right, so it's all new dwellings, isn't it? Not just ones over 50 units. There is a different thing for 50 units, but it's all new dwellings. Yeah. Okay. In terms of the sites over 50, I gather that there's 15 of these. I think there's 14 listed on page 8 of the council's Matter 1B statement, and then there's a further one that the council have identified that had been missed off somewhere. So there is a further one. So there's 15 of those, right? Okay. And then if I can just get your statement in terms of what the plan is doing in this respect. And I'm sort of referring mostly to your page 8 of your statement, the table there, where you say what you're doing. So you've got policy LP 32, which you refer to, which requires on-site open space provision for larger sites. And at this point, for larger sites, I wonder, is that of significant relevance to this? Because I'm envisaging this is your on-site space provision for larger sites, is I'm envisaging your sort of your children's play area type of thing, your small amenity area type of thing, presumably not the thing that is likely to encourage, say dog walkers to go there instead of travelling to the coast to walk on the coast and the beach and cause the problems there. Is that right, or have I misunderstood that? That's my understanding of policy LP 32. It'd be that sort of it's sort of site specific open space to meet needs, or have I misunderstood that? Mr. Kench?
Yeah, it's about retaining recreation on site as far as possible, so providing walking routes for dog walkers, so they don't travel to the coast on a regular basis. So it's about responsible access to nature rather than preventing it. So making sure people stay within their local area as much as possible, essentially, for a variety of measures. So dog walking bins, walks on site, adequate open space, and all that sort of thing will mean that people stay within their local area more often, and that's the intention. Right.
Okay. We'll perhaps come back to that in a second then, as to how that fits in with some of the other plan requirements. Okay. Did you want to say something more?
No.
All right. Okay. So then we've got SPO 9.2. Which we've just been talking about. Let me get that up, and this requires contributions towards mitigation measures identified in the Suffolk Coast RAMS. This applies to all residential development, not just those over 50, doesn't it? To be clear, but this only relates to mitigation. So this is saying pay some money towards, signs and interpretive boards and all that sort of stuff, and monitoring of visitors at the Suffolk Coast. It's not money to pay for any. It's not money to provide any alternative green space. That's right? Okay, and that applies to all new development within the 13-kilometre zone, right? Okay, understand that. So then we come on to the supporting text. Which in places, and this is, I think, where the 15 sites come up, which we've got. I'll go to Sproughton because that's one I've got as identified as falling within the 13-kilometre zone. So I'm looking at page 295 of the plan. And just above the allocation for LA 012, it says Sproughton falls within the RAMS 13-kilometre zone of influence. Therefore, contributions will be sought for all developments involving the creation of new dwellings. Right, so that's in effect repeating SP092, isn't it? Just a sort of reminder of that. And then it goes on to say in bold, for allocations of 50 dwellings or more, project level HRA will also be required in order to secure access to sufficient green space at application stage, in line with Annex either 1 or I of Natural England advice. Okay, I suppose my first comment on that is I think that statement needs to go in the relevant policies, because it's fundamental, isn't it? So I think needs to go in the relevant policies. So that's presumably all 15 of them, rather than just as some as a bit of supporting text, albeit a bit of bolded supporting text. So I think unless the council's got some very good reason why it shouldn't go in the policies, I think it should go in the policies. But secondly, just if I can understand, therefore, what that's saying. So that's saying this is for allocations of 50 dwellings. Okay, we've got 15 of those. A project level HRA will be required in order to secure access to sufficient green space. And I'm thinking, well, actually, the HRA won't secure access to green space. Well, if the HRA will identify how much green space, additional green space, is likely to be needed, won't it? In relation to this development, having regard to how close it is to the coast, what else there is in the vicinity, what the actual development is proposing itself, that will identify how much is needed. But the HRA doesn't to secure any green space in itself, does it? Or am I misunderstanding that? It would then require, if it says need green spaces, some additional green spaces needed, there would need to be other array, section 106 or whatever to secure that space. Am I right? Or
yeah, well, clearly there would need to be a mechanism that the competent authority could be satisfied was effective to deliver the open space, if that was being relied on by the HRA assessment in order to, as it were, internalise some of the recreational pressures from that development. And so if the HRA had relied on the provision of that open space in order to achieve that outcome, then the competent authority would need to know that there was an adequate mechanism in place for the delivery of that open space. Now, that may be that it is a matter which is dealt with through a planning obligation, but it may be that it's a matter that actually it's been embedded by the developer in their own proposals.
Yeah.
So it's part and parcel of the application. Obviously, it may vary depending on whether one's dealing with an outline application or a detailed application, but it may be that the developer has already proposed an area which is suitable to fulfill that open space function, and then it might be more appropriate to impose conditions on the planning permission, both to require its physical provision and probably to think about whether there needs to be any kind of condition on restricting occupation until it's been provided or until a certain proportion of it has been provided. So I think we wouldn't necessarily see it as it will always be one mechanism rather than another mechanism.
But the point is, the wording, it isn't the HRA that secures it, is it? It's the HRA that identifies the requirement for it.
Well, so if we take, and we do take your point that anything which is effectively going to be a requirement of an allocation ought to be in the policy itself, and not simply mentioned in the supporting text. The supporting text is certainly, it can legitimately explain the requirement, but it can't impose the requirement. So there needs to be something in the policy to impose the requirement. And if we're therefore going to look at, as it were, lifting some of that text that's in bold on page 295 into the allocations, then that would be the way to refer to the need to ensure that the measures proposed in the HRA are delivered by the proposal. But I say whether that's by 106 or whether that is perhaps a detailed matter.
Yeah, I wasn't so much concerned with that. It was just that. I mean, I think everybody would probably know what it means until if it goes into the policy like that, you then get some developer saying, well, it's the HRA that secures it. You haven't got any power to secure it in any other way, type of thing. So I was just wanting to make sure that the wording of the policy is effective. But I can leave you to come up with that. So then I suppose the next question then is, and this comes back to the point about the LP32. LP32 will be requiring these sites to, for example, LAO12 land north of Birstall Lane. That will be requiring that to provide open space provision, won't it? Now, assuming this wasn't within the zone of influence of the RAM, so it was elsewhere, and so HRA considerations didn't apply. What sort of open space provision are you envisaging? I mean, you won't know precisely, obviously, but what sort of open space provision are you envisaging, is the council envisaging, would be provided, or what you would be requiring as part of a 105 dwelling site? Are you able to comment on that, just so I can get a feel for what would be required if it isn't HRA, following the HRA, and what would be required if it was? So do you have any? Michael.
Well, I'd say I'll ask Mr. Hobbs if he can perhaps comment on the specifics. But obviously, one of the things that we've looked at in terms of the open space study is areas of surplus or deficit of different types of open space for particular areas. So that would obviously be one factor that would influence what one would normally be looking for. Then, in the light of that, you would then look at the, if I can call them, the ordinary recreational needs of the residential occupiers. So this is a non-HRA circumstance. So looking at the ordinary recreational needs, and so that would be things like obviously children's play space, informal play space, kickabout areas, but also informal amenity space. And then depending on the scale of development, either on-site or off-site contribution to formal recreational needs, sports pitches, and so on. Obviously, that would be the kind of the norm for the non-HRA cases. And then over and above that, for the HRA cases, if there was the ability to provide on-site open space, which could also serve to contain recreational demands that might otherwise go towards the habitat sites, that would be likely to be over and above that normal space. Having said that, obviously open space can have a multifunctional role. And so, for example, areas of informal open space that can be laid out in a way which would make them attractive to dog walking of a type that could be said to absorb some of that recreational pressure, you wouldn't necessarily need an additional area of land compared to the norm, but what you would need is to make sure that it was laid out in a way that meant that it was capable of fulfilling that wider recreational role.
That's the bit where I'm struggling. I mean, these sites aren't, as far as I'm aware, most of them aren't massive. So they're probably going to be relatively small areas of open space. And yes.
Well, I say it does depend, sir, because I say if you look at your examples at Sproughton, the first site is 105 dwellings. The second site, LAO 13, is 800 dwellings. So I think it very much depends on the particular circumstances as to whether what you might say as their normal open space requirement would be of a scale that would lend itself to fulfilling this wider role of I say accommodating green space that's playing a role in mitigating against adverse impacts on the European sites. I don't know if I want bring in Mr. Hobbs in case he's got anything he wants to add to the way that the councils see these policies being applied.
I mean, well, if I could just, I mean, so what you're saying is I'm just trying to get my head around what you've just said there. So basically, I'm looking at LA 13, which in very broad terms is about 2 to 3 times the, we know the, it's about 4 to 5 times as big as LA 12. But has 8 times as many houses. So that is implying that there would be more space for open space on LA 12, wouldn't it? I'm thinking that's logic what you're saying.
Well, yes, but it's a question of whether the open space that is being provided can be laid out in a way that makes it capable of fulfilling this wider role. Now that's going to be a detailed matter.
That's the point I'm saying. Are any of these sites individually, because it is going to be an individual thing, isn't it? Because it's got to be whatever is required on an individual site has got to be relative to the number of houses that the harm that would arise. So it's got to be relative to that. So are any of these sites of sufficient size, taking account of the number of houses that are proposed on them, to provide open space that would, at least for their own residents, if not, other residents, but at least for their own residents, likely to say this is of equal or sufficient quality and usefulness for me not to go 13 kilometers to the coast? That's the bit that I mean, yeah, I can well understand that on LAO 12 you would have some form of open space that dog walkers would, when they're just doing the 5-minute dog walk before they go to bed, they would use that as opposed to going another few hundred yards down the road. Yeah, perfectly accept that it could provide that. But could any of these sites provide the sort of open space which would prevent, well, not prevent, but discourage people from travelling 13 kilometres, presumably in their car, to walk their dog, which I'm thinking is much more your Sunday afternoon, good long walk along the beach, get there, out for several hours. Well, people aren't, I can't imagine that LAO12 could offer anything that would engage people dog walking for several hours.
No, well, I think if you take those two extremes, I think that's probably a fair comment. But in a sense, but
it's not an extreme, is it? It's not an extreme. It's the reality of who is. Well, I don't know. It's the reality of who I imagine is going to the coast. That's why you've got this 13-kilometre thing, because it's recognised that people travel a long way to go to this zone because this land, because it's an attractive place to go, and people will go a long way to go there. I mean, perhaps if I can come to Natural England on this, Mr. Kench, are you? I think. I mean, I know there's been a lot of debate over this between you and the council, and you've got the plan to say what it says, and I think I'm not concerned that the plan would be approving these sites without this being dealt with, because we've now got that highlighted text that will go into policy, and that would all be all right. My concern is, well, in reality, are any or many of these large sites going to be able to deliver this? They haven't got the land, have they? That's my concern. And are they then, which then comes back to me as, well, are these sites deliverable if actually none of them are going to be able to meet the requirements of the plan because they can't provide what will be necessary? Or from your point of view, you would be closely involved in the HRA. Do you envisage sites of these sizes would be able to provide something that would be of significant attractiveness to attract people to use them rather than go to the coast?
It's very difficult for me to comment on individual site allocations without knowing the densities and things like that. There's so much variation, and a lot of this can't be identified until you get to the project level HRA anyway.
Yeah.
But what I would say is there's a couple of things. It's about daily dog walks, so stopping people from going to the coast on their weekends and things like that. That's not what we're aiming to do with this plan. With the RAM strategy, it's about retaining daily needs. So that is your 15, 20-minute dog walk. And that's involves public rights of way as well. So it's not just about the space on the site itself, but it's about connectivity to the local area, because you could be in a very rural area and have lots of public rights of way surrounding the site that offers you a 2.7 kilometre dog walk essentially for your daily needs. So it's a complex issue, and it really does depend on site quality and quantity. So it's all about providing, the space on site doesn't need to be huge, but as long as it's really high quality and it's sort of naturalistic in its style and people enjoy being there, then that's the key thing. But it's about a suite of measures that all work together. But it'd be very hard for me to comment on individual site allocations without, if that's okay.
That's great. Yeah. Just so I can so basically you're saying that it isn't necessarily about the scale of it, and something that fairly small in terms of open space, but was of a suitable high quality and attractive, would satisfy you that would be an effective alternative to the coast. Now, you're the experts on that, not me. But if you would be satisfied that could potentially could be the case, as opposed to needing something very large and extensive, maybe not as big as the coast, but something large and extensive that would be an attractive alternative to the coast.
It just needs to be proportional. So we never assign a percentage or anything to the amount of public open space on site, and that's the key thing. There's lots of guidance out there for the developers and for the council to sort of go by. So I can't quite tell you based on the size of it. It really does depend on local
Right.
circumstances. If I'm completely honest, now I find it very difficult to say. But yeah, we have got sites where there is sites across Bayber and Mid Suffolk that do have, a relatively small public open space area, but there could be a suitable distance away from the coastal sites that, going to the coast every day isn't appealing. So there's a lot of factors involved. It's, you could be from 1 kilometre to 13 kilometres away from the coast. If you're 13, it's unlikely that you're going to be going there on a daily basis. So a smaller public open space, that wouldn't matter so much.
Right.
Do you understand what I mean? You're unlikely to travel to, the very, the Old Ore Estuary or something from somewhere in Bayber, Mid Suffolk, or the Deben. I suppose that would be within 13 kilometres on a daily basis if you're on the periphery of that 13 kilometres. So yeah, there's just a lot to be taken into account.
Okay, so the distance, you've got the zone of influence, but as part of the HRA, you would consider the distance. So if it was right next to it, then you'd be looking for something substantially more than if it was at 13. And just so I'm clear, so you're saying it isn't the weekly long walk along the coast or whatever, or the monthly long walk. It's your daily, twice daily. Going right, okay. Okay, and that's presumably just because the daily, twice daily is happening, 7 times more than your weekly.
That's absolutely, it's the frequency. Yeah.
Okay. I mean, just so one of the, I've dealt with a number of plan examinations that raise this same issue, and SANGs have been proposed. So that's, suitable alternative natural green space. They have been, there's been complicated arrangements, but whereby a number of sites are required to contribute towards the development of some SANGs, and these SANGs is a fairly large development in its own right of large open space, and not on any individual site, but much closer to closer to the allocations, the housing allocations, than the protected habitat is, and they all contribute towards the development of this. So they 5 or 6 sites are sharing and contributing towards one SANGs. That hasn't been that hasn't been chosen as the way forward here. And I note the RAMS document makes very little comment. It does refer to SANGs, I think, once, and sort of says there's one example of a SANGs, but not generally as the way for going forward. Is there a reason? I don't know. Well, either the Council or Natural England on this, really. Is there a reason why that approach, which is common elsewhere, isn't being adopted here? I'm not saying it's necessarily everywhere, and it might not always be necessary, but is there a reason why that approach isn't being adopted here?
I think I'll probably ask Ms. Dawson if she's got any initial comments on that. Obviously, Sarah, as you will be well aware, not all European sites which are experiencing recreational pressure are themselves of the same character, and the biodiversity interest in them is not always the same. Obviously, the SANGs concept certainly, I think, had its genesis in the mitigations that were being provided for the Thames Basin Heaths SPAs, where there were particular issues with the ground nesting birds there, and then similarly in the Dorset Heaths, where again particular issues, and again with ground nesting birds, and it wouldn't necessarily be the same, albeit there are ground nesting birds on some parts of the Suffolk coast habitat sites. But I say I'll ask Ms. Dawson if she can perhaps reflect or explain a little bit more on the thinking that has informed the RAMS specific strategy for this area, and what view has been taken about the role, if any, of SANGs as opposed to, as a sense, a more fluid or iterative approach, which is, I think, the sort of thing Mr. Kench was talking about, whereas you look at the specific proposal on a specific site and see what could be done to improve connectivity to rights of way, access to heathland, or let's say you've got a site in a settlement which has got there's an existing village green sort of thing, but there's not a good connection to it, and whether or not you could improve the connections to it through the way that the development is laid out or arranged. But I say I'll ask Miss Dawson if she can comment on the overall approach.
Thank you. Regarding the RAMs, that came about with the support of partnership authorities and Natural England, as I'm sure you're aware. The SANGS isn't part of the RAMs, because the RAMs is purely to do with recreational disturbance and the mitigation required for the protection of the SPA and the protected species areas along the coastline. And so that is purely a contribution to support with educating people through, like I say, wardens or rangers, signs, and alternative walks to protect the protected areas of habitats for the overwintering birds, etc. That is to do with off-site contributions, and it is an option. It's not a formal, you have to do this. If a development site doesn't wish to enter into the RAMs, that is not an issue, as in it's a request, a sort of like an option, because the strategy has already been assessed and there's a cumulative impact of a development's, the expected amount of development that's going to take place within that 13-kilometre zone. But if a development site doesn't wish to do that, then they can do their own HRA. But it is purely to do with the contributions off-site, whereas if it's a larger site, SANGS would be normally on-site, and that triggers a different form of contribution, or Section 106. And as already has been sort of like explained by Mr. Kench and Mr. Bedford, the triggers of what that may entail. And because we're primarily 2 rural districts, there are a lot of really lovely areas, and it may actually be accessibility to those areas so that people can enjoy more local, on the doorstep facilities and natural walks, rather than them feeling that they're isolated, regardless of whether they're in the countryside. So they sort of say, well, we might just drive all the way down to the coastline.
So are you confident that the necessary open space for these 15 sites will be able to be accommodated on them, that the necessary open space, having regard to it might be improving access to paths in the area, that type of thing? Are you I mean, I suppose what I'm saying is, are you confident that what is required as a result of the HRA in terms of access for recreational, for recreation, will be able to be provided by these developments? You can't say 100% sure, because obviously it depends on what the developer says, but are you confident that where they are, the size of them, they will be able to deliver this? Because that's my ultimate concern. What I don't want is to say a plan's fine based on these 15 large sites. Actually, none of them can come forward because they can't satisfy HRA. Having said that, I mean, I suppose there is a thing in here in that some of them already are coming forward, aren't they? A number, I haven't got the list in front of me. So, I mean, in terms of, are you able to, I don't know if this is more Mr. Hobbs, are any of the 15 have got planning permission? Some of them surely have, haven't they? Are you able to refer to one of them that's got planning permission and tell me briefly, I mean, I don't know if you know the answer to this, but tell me briefly what was done in terms of open space to ensure that HRA was met, and what I presume there was a project level HRA.
Sorry, yes. So I see we one of the play services team, Ms. Hooton, is able to probably answer on that. I think it's certainly right that the land northwest of Moores Lane at East Bergholt has got a planning permission.
Right. Okay. Let me just get that one. Oops, that's LAO 60, isn't it? Right. Okay. So, Ms. Hooton, do you want to comment on this point? Are you able to comment? What?
Thank you, sir. I was going to comment on LAO 16, land west of Bourne Hill, Worsted.
Okay, that's fine. Any of them will do.
That's fine. Mainly, sir, because we had a project level HRA.
If you can just hold on a second, let me just find.
Okay, no problem.
Is it Mid Suffolk or
It's Baber.
Oh, Baber. So. Yeah, got that. Yeah.
Okay, sure. So I'm not sure if the details in front of you show that it's actually within walking distance of the Orwell Estuary, which is part of the SBA and Ramsar. So it's very close. And because of that, we did require at application stage an identified need within the project level HRA that it would need considerable green space and access to additional green space to avoid people on a daily basis, possibly twice daily basis, from walking down to the estuary and letting the dog off the lead. Right. So we did actually require as much green space within the development as possible. There is an additional parcel of land next to the development that we identified as providing some provision towards SANG, so suitable alternative natural green space, but it wasn't sufficient to deter people walking to the coast. And therefore we identified a need for additional connectivity to a large park, again within walking distance, but there's now a considerable length of walk, up to an hour if necessary, within that park, within the adjoining authority, that creates a very long walking route, which Natural England felt was sufficient to deter people from walking to the estuary on a daily basis. So it's about provision on site, potentially additional land within the applicant's control. But if that's still not sufficient, we will require improved connectivity to sufficient, basically SANG, but it was already in existence.
Okay, so just there's an example of one site where it's got planning permission, it's been through all that's the things. Are you as somebody who would be presumably or potentially involved in some of these HRAs, are you and you've looked at the plan closely, obviously, are you confident that each of these 15 sites could, you can't give 100% guarantee, I appreciate that, but you're confident that they could deliver something?
Yes, sir.
Yeah, right.
We've looked at an individual level when applications have come forward. Quite a few of these have got consent, but not many are commencing yet. But all of them, I think, that have already come forward have had a detailed project level HRA, which has identified the individual need. But a lot of them, we feel, can be supported by improved connectivity, as Mr. Kent has suggested, to provide that daily walking route of 2.7 kilometres, which is what Hampshire County Council have identified as the average walking route. So.
Right. Okay. Okay. Let me just. I think that covers that. So, is there anything else that anybody wants to say on recreational disturbance? That's been helpful to me. No. Okay. That's good. Well then. Finally, yeah, it's just this issue of the 2 site allocations on priority habitat. So understand these are LSO 123 Stoke by Nayland, which the council has now proposed to delete from the plan. Obviously, they are part of the plan, so we will, my colleague and I, we will need to consider whether or not it's appropriate to delete them from the site, and then take account of any representations that come in if we can do any main modification on that. So there's quite a few steps to go through in terms of that, but in principle, I would sort of say I can understand why the council wants to remove from the plan a site which is on priority habitat. That then brings us to LSO 163, which is Oakley, which remains in the plan. I just sort of wonder why. I mean, it's a small site. The council isn't looking for every last scrap of land to meet its base housing need type of thing. There's a 20% buffer already. Why is the council allocating what I understand to be, well, first of all, is it priority habitat? And if so, why is the council allocating housing on a site which is priority habitat?
I'll probably ask Mr. Hobbs to start on that, and then if there's necessary to bring in any of the place services team to comment.
Thank you. The site allocation at Oakley is along the road frontage, and it's a field effectively there, and it's also being promoted in the Diston District Neighbourhood Plan as well for an allocation.
Right, but that's sort of useful background information, but it doesn't. So basically, saying because is it in the neighbourhood plan, or is it being?
Yeah, they've gone through regulation 14 stage.
But it's not been. It's not.
Oh, so it's not made. No.
No, it's not a made neighbourhood plan. I mean, national policy. Looking for the relevant bit. I mean. I can't find immediately the precise words it does say, but it isn't supportive of saying, oh yeah, by the way, priority habitat is in principle a suitable place to have a housing allocation, is it? It is warning against it.
I think I need to have a look at the site in more detail, but certainly there's priority habitat is quite an extensive area of land in that location, and what we're talking about here is a very small piece of land adjacent to the road frontage. So I do wonder whether it's getting a bit confused with maybe the priority habitat to the rear of the site, which is very different to the actual frontage that is proposed to be allocated. For example, cows are on the site to the rear where the priority habitat is, whereas, like I said, this is an enclosure effectively at the frontage adjacent to the road.
So are you saying it might not actually be priority habitat, or it might be mistakenly identified?
It was certainly at the fringe, yeah, exactly. That's my point.
Okay. I mean, I think we'll come back to it on matter 9, and we need to explore it again at that stage. But I just wanted the council. I mean, the council's view on it, but I'm looking for the bit in terms of national policy where it. Well, here we are. If significant harm, this is paragraph 180, when determining planning applications, local planning authorities should apply the following principles. If significant harm to biodiversity resulting from a development cannot be avoided through locating on an alternative site with less harmful impacts, adequately mitigated or at last resort compensated for, then planning permission should be refused. So, I mean, that isn't directly relating to priority habitat sites and local plan allocations, but none of that is saying, oh yeah, priority habitat a great location for housing developments, is it?
It isn't, but it does recognise that there's a mitigation hierarchy, which if you follow it through, you may end up coming to a conclusion that it can be accepted.
Yeah. So why then, the reason the council's given for the Stoke by Nayland site being deleted from the plan is because of biodiversity impact. So is the council, you're confident that there is a significant difference? I mean, obviously they are two different sites, but you're confident that there's a significant difference between these two sites warranting one to be deleted from the plan and the other not?
Well, so I think obviously you've highlighted an issue, and it's clear we need to provide a clearer explanation. I think perhaps Mr. Hobbs will want to take away that point and perhaps provide you with a note that in a sense explains that it's not an arbitrary position of one out, one in, and provide you with a note that articulates why there is a different treatment of those two sites.
Okay, I mean, that's fair enough. We'll leave it. We'll come back and discuss it again. Both sites at Matter 9. So we'll leave that till then, unless there's anything else anybody wants to say on the priority habitat sites. I mean, I notice it's raised in the statement of common ground. That's how it was brought to my attention that it was priority habitat site. So it was presumably of some concern to Natural England, albeit I don't think you formally objected. Okay. Right. Thank you for that. That's all I needed to cover on that, unless there's anything else from anybody else on on habitats regulations assessment. No. Okay. Well, thank you to all for your participation. Thank you, Mr. Kench, and the ecology consultants. Probably not be seeing you again, but you're welcome to come along if there's a relevant thing to talk about. But thank you for your contributions. Obviously, Mr. Bedford, Mr. Hobbs, I'll be seeing you again next week, probably.